Hi, Brian.
Oh,
Oh, really?
again, good afternoon.
Good
Good
afternoon.
afternoon, everyone, and welcome. Um, uh, uh, we're here, and we're looking forward to this conversation and this discussion. Um, I want to ask everyone, if you haven't yet, to please mute your phones so that we can have a full, fair conversation and we can hear our presenters. Thank you very much. Um, what we like to do, though, at the outset is have a moment of silence for George Floyd, Breonna Taylor, Tony McKay, Ahmaud Arbery, Charlena Lyles, Philando Castile, Tamir Rice, Sandra Bland, Walter Scott, Tanisha Anderson, Sam Du Bois, Yvette Smith, and so many others that we have lost and for whom we still grieve. Uh, we'd like to take 8 minutes and 46 seconds of silence, beginning now. Thank you. So I wanted to take a few moments to introduce and frame the topic we're going to have a conversation about today, and then introduce the presenters to you by telling you a little bit about them and their background. In considering and reflecting on the events of the last weeks, certainly, if not the last several weeks, there have been a lot of questions around the what's and the whys of the law as regarded the killing of George Floyd. And a lot of people had a lot of questions about it. And in addition to making sense of the horrific tragedy as it regards race in our society today. And people were experiencing a range of not only just emotions and feelings, but wanting some understanding of how the law works and how policy works in this context that we see, and make some sense out of it. So the goal of this particular session was to be informative and educational, and also to be narrow in scope in the sense that this session here is just really focusing on the killing of George Floyd, and the complexities of the law and the facts with regards to that particular event. And as we all understand and appreciate, there are so many things, so many other things that we need to think about, we can think about, we all have questions about, and we all must consider. And we will be doing that. But this particular session is just focused on the killing of George Floyd. I'll talk to you a little bit later about some of our ideas and plans about what comes next in terms of these Zoom meetings and Zoom town halls. And hopefully you'll be able to come back with us when we do some more of these. But I wanted to just sort of introduce, well, not sort of, I just want to introduce now the people who are going to be talking to you and talking with us and educating us. Starting with Deb Ahrens. Deb Evans is a tenured associate professor at Seattle University School of Law, where she teaches criminal law, criminal procedure, and evidence. Now, Professor Ahrens earned an AB in public policy from Brown University. She received her master's in public policy from Harvard University's John F. Kennedy School of Law, and her JD, magna cum laude from New York University, where she was a senior articles editor of the Law Review. Before joining the faculty at Seattle University, Professor Ahrens served as a law clerk for Judge Amalia Pierce of the United States Court of Appeals for the Second Circuit, a legal fellow at the ACLU's Drug Policy Litigation Project, an assistant public defender at the Richland County, that's South Carolina Public Defender, and a visiting assistant professor of law at the University of South Carolina School of Law. From 2017 to 2019, Deb served as the William Oatman Professor of Teaching Excellence. And if you ask any of her students, or if you've ever seen her in action, you would know why. Her scholarship focuses on the cultural significance of contemporary policing practices and criminal sanctioning regimes, with particular emphasis on drug policy and on the regulation of student speech and conduct. Deb is a frequent speaker and commentator at academic and professional events, and for the popular media on a wide variety of criminal procedure, evidence, policing, and sentencing issues. And I'm proud and honored to say that she is a colleague and a dear friend, and I just can't thank you enough for being here, Deb. Ayesha Bell Hardaway is another dear friend and colleague, and is an assistant professor at the Case Western Reserve University School of Law. As a member of that faculty, Professor Hardaway teaches in the clinic as a clinician in the Milton A. Kramer Law Clinic, and has worked with students in the areas of criminal justice, civil litigation, and health law. Professor Hardaway is currently the director of the Criminal Defense Clinic, where she supervises students in their first shared direct representation of clients accused of misdemeanor crimes in the greater Cleveland area. Now, the pedagogical framework of the Criminal Defense Clinic is designed to provide exemplary legal services to clients. The foundation that service is established through Professor Hardaway's seminar in two ways. The first way, at criminal defense clinic, students receive instruction on the statutory and sentencing requirements of commonly charged misdemeanor crimes, including, for example, driving under suspension, domestic violence, theft, assault, operating a vehicle while intoxicated, and disorderly conduct. A second, and of equal importance, students in the criminal defense clinic explore issues of race, issues of poverty, as well as the legal and non-legal collateral consequences of misdemeanor charges and offenses. Now, in addition to her teaching responsibilities, most relevantly and importantly here, Professor Hardaway is currently serving as the deputy monitor of the independent monitoring team that was appointed to evaluate the progress and implementation of Cleveland Police Department reforms mandated by a settlement agreement between the City of Cleveland and the Department of Justice. Her research and scholarship interests include the intersection of race with constitutional law, criminal law, policing, and civil litigation. Professor Hardaway is also the director of Case Western Reserve University's School of Law's Social Justice Law Center. Prior to joining the law school faculty there, Professor Hardaway practiced in the litigation department of Tucker Ellis, LLP, and her 6 years at that firm, she was devoted primarily to defending major electrical, automotive, and pharmaceutical manufacturers during all phases of litigation, and as trial counsel and national coordinating counsel. Professor Hardaway represented those clients in both state and federal courts throughout the country. But before her time at Tucker Ellis, Professor Hardaway was an assistant prosecuting attorney for Cuyahoga County, that is where Cleveland is the county seat, and handled a variety of criminal matters, including juvenile delinquencies and general felonies. She is a prolific scholar. Some of her publications include Creating Space for Community Representation in Police Reform Litigation, which is forthcoming in Georgetown Law Journal, the Supreme Court and the Illegitimacy of Lawless Fourth Amendment Policing, which is forthcoming in the Boston University Law Review, Time is Not on Our Side, Why Specious Claims of Collective Bargaining Rights Should Not Be Allowed to Delay Police Reform, The Paradox of the Right to Contract, The Breach of Common Law Trust Relationship Between the United States and African Americans, A Substantive Right to Reparations, that's in the New York University Review of Law and Social Change, and including The Case for International Reparations for Slavery, Is Moral and Lawful, Even if It's Hard to Prove. So without further ado, I welcome you, Ayesha, to this conversation. Some ground rules, though, before we begin asking our panelists or our co-discussants the questions. We're going to have a Q&A after we go through a series of questions. And if you have a question, you can ask it in one of two ways. You can raise your hand. If you're familiar with Zoom, you'll see that it has a hand raising function. If you look in the, I believe, participants icon. You can also put it in chat. You'll also see at the bottom, you should see at the bottom of your screen an icon for chat. And there you can also enter your question. And my colleague, Claudine Benmar, is going to be managing and navigating the Q&A. And I, at the outset, want to give her my deepest thanks. And we should all give her our deepest thanks for making this thing technically possible. And this is a wonderful job that she has done for us. And so I just want to honor you and say thank you so much for this, Claudine. All right, so here we go. I wanted to start by asking Ayesha and Deb this question. First, as criminal law attorneys and law professors, how do you view the Floyd killing and the way in which it shines a light on these intersections between race and the law?
Is that me first?
Sure.
Okay, great. So first off, Bryan, let me tell you how grateful I am for your leadership in creating space for this conversation. I hope you guys can hear me all okay. It would be an understatement to say that it's a joy to be able to work with you again. So thank you for creating this. And it's also encouraging to know that there's so many people out there who are not just interested in this topic, but interested in the work that needs to be done around this topic. And so I'm grateful for all of you that are here joining us virtually today. As to the question about the deliberate killing of Mr. Floyd in the streets in Minneapolis 11 days ago, let me just say that it is an in-the-face representation from my perspective of what Black men, women, and children experience during encounters with law enforcement, countless times every day in America. Do all of them end up with the same hands-on, barbaric, brutal killing that the world has witnessed? Obviously not. But surely we know that Black people are disproportionately killed by the hands, bullets, and even tasers of law enforcement in our country. But I'd like to submit to you that the blatant physical violence that the world is reacting to, once again in this current moment, is emblematic of the violence that Black men, women, and children suffer through the widespread over-policing of our communities and our activities. This is evidenced in a number of different ways, but I'll highlight just a couple of them for you guys today. It's evidenced in the pretextual traffic stops that the Supreme Court has deemed lawful, that are based on racist enforcement strategies. Those strategies target Black drivers and provide financial support from municipal courts and governments throughout our country, not just in Ferguson. It's also evident in the ways that arrests, pretrial detentions, sentencings, and probation constraints not only interrupt, but destroy the lives of Black men and women and children who are disproportionately subjected to minor criminal charges, oftentimes with very little or no evidence of guilt. My work in the clinic has given me a front row seat to the way that police, prosecutors, the courts, and dare I say, even criminal defense attorneys dehumanize Black people in their interactions. And so that's just current day, right? Mr. Floyd's killing is emblematic of how the place we call America, the place we now call America, has had its proverbial knee on the neck of Black folks since 1619. I'll stop there and allow Deb to share her thoughts. Thank you.
And I want to also offer my thanks to Bryan for organizing this and taking the leadership role on this, and for providing this space for people who care about these issues to be able to talk. I wish we could all be in a room. I'm glad that we have this sense of community and that we can have a conversation. And I hope that we can be of assistance in answering the questions that you likely have. I think that what I wanted to talk about briefly is that our criminal justice system, policing, these are things, nothing is by accident. Everything we do is a choice. And those choices that we've made historically have been not just kind of incidental to or somehow implicitly, but explicitly and expressly about race. I write, as Bryan's talked to you about, primarily in the issue of drug policy. And that's an area where it's not just that we make the decision to put police in particular neighborhoods and that we make those decisions based on race. It's not just that we stop Black drivers more often. It's not just that we're more likely to arrest them. It's not just that it's more likely that an otherwise nonviolent, non-confrontational encounter between police officers and a Black man will end in violence than if they were facing a white driver. It's that the laws themselves are imbued with race, that they were adopted for racist reasons in order to disfavor particular groups at different points in history, and they're still with us. So all of this that we're going to be talking about today, these are choices we're making. These aren't just things that happen. And we have to reflect on those choices, and we have to make better choices going forward. And you want to ask yourself questions, not just about how this particular encounter ended in tragedy and violence and murder, but rather, what is the officer doing there in the first place, performing a full custodial arrest of someone who allegedly has presented a counterfeit $20 bill? How did we get there? Why are those the choices we're making? And why is the use of force in such an encounter an option at all? And so those are the kinds of things I want you to be asking yourself throughout this. And then hopefully at the end, we'll have a conversation about what kinds of solutions we can have going forward.
Thank you, Deb. I don't know who wants to start first, maybe Ayesha. Want to describe your understanding of that encounter. Yeah, describe your understanding of that encounter and the existing legal and factual circumstances around that encounter. Ayesha, you want to start off?
Sure, I will. I think Deb set it up really nicely in terms of the facts. So I want to just see if I can be crafty enough here to share my screen. I'm going to try and hope that I have some success. Let's see. There we go. Is that good?
Yes.
Alrighty. So I think it's important for us to start with a picture of what we know at this point. And this is based on not just the bystander video that's gone viral, but also the details of the probable cause statements that the Minnesota Attorney General has released over the last couple of days. And so those statements refer to 911 calls and body cam footage, EMS records, and the county autopsy report that I'm sure you all have heard about. The majority of which, with the exception of the autopsy report, have not been released publicly. And so I say all of that to say this is all very preliminary, right? And those of you who are lawyers listening on this, you know many better than me, that what really matters is the evidence presented at trial and how the jury weighs it. But with that major disclaimer, I offer the following reported facts for your consideration. An employee of a local grocery store did in fact call 911 and reported that a man tendered a fake $20 bill while paying for merchandise. Two officers, Thomas Lane and J. Alexander Kung, arrived at 8:08 p.m. and were told by someone working at the store that the man was sitting in a parked car around the corner. I don't know if the employee directly pointed out Mr. Floyd as the man who tendered the alleged fake money, or if police were provided a sufficient description to lead them to reasonably suspect that Mr. Floyd was in fact the individual in question. But I think that that is an important question that folks will have to figure out. Either way, we know that Officer Lane, in response to the call for service related to a nonviolent crime that is punishable as an initial batter in Minnesota by no more than 1 year in prison and up to a $3,000 fine, forgive me, that Officer Lane then pointed his gun at the driver's side window where Mr. Floyd was sitting in a car. There was no report of any violence or any weapon, but that was how he was first approached. Mr. Floyd complied with Lane's command to put his hands on the steering wheel, and the body cam purportedly shows that Mr. Floyd that Mr. Floyd did not resist in any way, that he complied with the command to get out of the car, and that he was handcuffed. No mention of a struggle. Once Mr. Floyd gets out of the driver's seat and in handcuffs, he was reportedly calm and even said thank you to Mr. Lane, to Officer Lane, when he was sat down on the ground near a building. That was when there was then reportedly a brief conversation had between Officer Lane and Mr. Floyd, where he was asked for his name and identification, and then told he was being arrested for passing counterfeit money. After 6 minutes, the first two officers arrived on the scene. After the first two officers arrived at the store, Kung and Lang attempted to place Mr. Floyd in their patrol car. It is reported that this is when Mr. Floyd stiffens and falls to the ground and says he's claustrophobic. He also reportedly tells officers that he's not resisting. It is some time after or during this exchange that Officers Chauvin and Tao arrive. And at this point, what's described by three officers as attempting to get Mr. Floyd into the backseat of a patrol car, they're pushing him, and he's repeatedly saying that he can't breathe. An early charging statement describes Mr. Floyd as being over 6 feet tall and more than 200 pounds. It's not in the most recent probable cause statements, but it is out there for public consumption, and so I'll give that to you as well. And after being on the scene for more than 5 minutes, Chauvin pulls Mr. Floyd out of the patrol car, and he's immediately placed face down on the ground, still handcuffed. Kung holds his back while Lane holds his legs, and Chauvin puts his knee on Mr. Floyd's head and neck area. And the three of them stay there for the next 8+ minutes. They respond to Mr. Floyd's repeated statements about not being able to breathe by asking if he's having fun, whether he's a tough guy, and by telling him that he's talking just fine. At some point, Lane, the officer who's holding his legs, asked if they should roll Mr. Floyd to his side. Chauvin declines and says that we're staying put where we got him. Officer Tao reportedly at some point goes to a patrol car and gets a hobble restraint, which I can describe later if folks want to talk about that, from a police car, but they decide not to use it. And when a bystander steps off of the sidewalk towards Chauvin and Floyd, Tao keeps them from passing by placing his hand up. After Mr. Floyd stops breathing or speaking, Lane reportedly asks again about rolling him to his side. They check for a pulse, and Chauvin leaves his knee on Mr. Floyd's neck for more than 2 more minutes, even after they don't find the pulse. With those details as the backdrop of the circumstances, all 4 officers were fired, as we know, and eventually charged with a variety of offenses. I want to go over those offenses briefly just to set up the opportunity for Professor Ahrens to discuss the evidentiary issues at trial. So the first count facing Mr. Chauvin, as you likely learned yesterday, he now faces murder, 3 charges. The first is murder in the 2nd degree. That is punishable by up to 40 years in prison and requires the state to prove that he caused Mr. Floyd's death without the intent to do so, but while committing the crime of assault in the 3rd degree. He's also charged with murder in the 3rd degree, which is punishable by up to 25 years in prison, and requires the state to show that while Chauvin committed an imminently dangerous act and without regard for human life, he caused Mr. Floyd's death. And the final charge that Chauvin is facing is manslaughter in the 2nd degree. He could get no prison time, no more than 10 years in prison, and or a fine of no more than $20,000. The state will have to prove that he was culpably negligent when he consciously took the chance of causing the death of Mr. Floyd. As for the other 3 officers, they are each facing a charge of aiding and abetting 2nd degree murder, which is not subject to more than 40 years in prison, and requiring proof that they intentionally aided Mr. Chauvin in the commission of 3rd degree assault that resulted in Mr. Floyd's death. And the final charge that they're facing is 2nd degree manslaughter, aiding and abetting 2nd degree manslaughter, which is punishable in the same way as 2nd degree manslaughter in and of itself is, again, by no more than 10 years, but could also be no prison time and or a payment of a fine of no more than $20,000. But also that requires the same evidence of proof, culpable negligence, taking the chance of causing the death or causing great bodily harm to Mr. Floyd. So with that, Professor Ahrens, I'd like to turn it over to you. I'll stop sharing my screen. Okay.
Right, and with that, I am going to go ahead and start sharing mine. And so if you can just give me 1 moment here. What I'm going to do is just talk very briefly about the charging decisions here and what I see as possible issues that people might want to think about. That, again, we're early in the investigation. It's not clear exactly what kind of evidence is going to arise. There's body cam footage, for example, from the police officers that hasn't been publicly released. So I'm just going to speak based on what we know so far and a little bit based on what we know about the charges. And a couple of really quick things. One, I'm going to try to make this a conversation that those of you, and pardon me, let me go ahead and actually start the slideshow, that those of you who may or may not have a legal background will more or less be able to follow. But I am also going to, for those of you who do either have a background in criminal law or have at least taken criminal law, some things that you might be familiar with to kind of contextualize Minnesota law. And I, of course, do want to offer the disclaimer, I have not personally practiced in the state of Minnesota, so it is possible that some of what I say might not be how things actually play out in Minnesota, but I have researched the state law at least a little bit, and so I think I can talk certainly about what the law says and how I think it probably applies to the facts here. So one question that I've fielded from a number of people out in real life is, why is this not being charged as first-degree murder? And I'm just going to give you, this is an excerpt from the first-degree murder statute in Minnesota, which requires that, and there has been the death of a human being here, but that the defendant causes the death of the human being with premeditation and with intent to affect the death of the person or of another. So this isn't a charge in the case. I'm not going to spend a huge amount of time on it, but note that there are two different things that have to be going on in the person's head. One, they have to intend to kill, which in criminal law generally means they either are purposely killing someone or that they know that their actions are going to result in death. And when they do that, they have to have premeditation. And premeditation, I think often in the popular press is described as like planning far in advance, like a hit person would. And that's generally not what the law requires. Doesn't appear to be what the law requires in Minnesota. You can deliberately decide to kill someone and then a few minutes later actually do it. So I don't know that first-degree murder would be completely out of bounds here. But premeditation usually does require, not necessarily as an element of the law, but as a matter of practicality, for you to show things like maybe a history of animus between the defendant and the victim, or some words that the defendant said at the time or after the events that suggested that they really reflected on what they were doing and decided to proceed forward. So that's what first-degree murder would require, both that the killing be intentional as well as that the person performing the killing have premeditated it. Second-degree murder is, of course, the charge here. And there are two ways you can get to second-degree murder in Minnesota, one of which is if you intentionally cause a death without premeditation, which isn't the basis actually for the second-degree murder charge against Derek Chauvin here. He's actually being charged under the second provision I have here, unintentional murder, which is where the defendant causes the death of a human being without intent to affect the death of any person while attempting to commit a felony offense. And here's where things are going to sound a little strange for those of you who don't have a law background. But what this means is that the person, in order to be convicted of second-degree murder, doesn't have to intend that anyone die, doesn't have to know that anyone is going to die. It's just that they participate in some sort of felony. They have whatever mental state they need in order to participate in that felony. And as a result of that felony, somebody dies. So a typical case might be, for example, if a landlord set a house on fire in order to maybe scare their tenants out of the house, and then somebody in the home died of smoke inhalation, they're committing a felony. Maybe that's something that looks like third-degree murder, which I'll talk about in just a moment, but you don't have to prove that. They committed an arson, which is a felony. Someone died as a result. That's felony murder. And a couple of things that are interesting about Minnesota law. In most jurisdictions, if what the predicate felony is, in other words, the felony that's the basis for felony murder, if what it is, as Professor Hardaway has described, assault, that can't be a predicate felony for felony murder in the majority of jurisdictions. There's a doctrine called merger that says if you assault someone and as a result of that somebody dies, the assault merges into the killing. It's integral to the killing. And so it can't be a predicate felony. Felony murder is for something where the felony is a non-assaultive felony. So you're committing a bank robbery or you're committing a kidnapping, something where the assault isn't kind of integral to the felony. That doesn't seem to be the case in Minnesota. The court there has expressly said they don't have a merger doctrine, so you can use assault as a predicate felony in felony murder in the state of Minnesota. So that makes Minnesota somewhat unusual, and it is perhaps what's allowed the state attorney general there to charge second-degree murder in this case. Finally, third-degree murder is whoever, without intent to affect the death of any person, causes the death of another by perpetuating an act eminently dangerous to others and evincing a depraved mind without regard for human life. This is what in most jurisdictions we would call depraved indifference murder. Again, Minnesota is a little unusual. In most jurisdictions, this is second-degree murder. This is what we call depraved heart murder. And it's the kind of murder where the person who perpetrates it knows that they're creating a substantial risk of death and just doesn't care. They literally don't care if other people live or die. So think about someone who fires into an occupied house or throws cinder blocks off of an overpass. It's not that they specifically intend to kill someone, They just don't care if people live or die. And that's what, of course, the officer was originally charged with here, not intentionally killing someone, not committing a felony, and as a result of it, somebody died, but rather just not caring if the person that he was encountering lived or died. Of course, we also have second-degree manslaughter, which, as Professor Hardaway has described to you, has a negligence standard, which is a little bit lower than that kind of recklessness, depraved indifference, I don't care if people live or die standard that I described in third-degree murder. This is somebody who may not even be aware that they're doing something really risky, but they ought to be. They ought to understand that that risk occurs. Finally, you have our other officers who have been now charged as accomplices. And Minnesota is typical in that if you're charged with aiding and abetting an offense, it's as if you did the thing yourself. The hand of one is the hand of all. You are not charged with some sort of lesser offense because you stood there and you helped out. You're charged with the exact same offense as the person who actually committed the criminal activity. So if the person intentionally aids, advises, hires, counsels, or conspires with, or otherwise procures the other to commit the crime, here you have to intend that the crime be committed and you have to intend to help out. And that's all this requires. Once you do that, you are now on the hook for whatever the principal does. And here the officers are charged with aiding and abetting the predicate felony. Finally, just the assault. Assault is an act done with intent to cause fear in another of immediate bodily harm or death, or the intentional infliction or attempt to inflict bodily harm upon another. You need that definition because third-degree assault in Minnesota doesn't contain it. This is what third-degree assault is. It's assault, so that intentional infliction of harm where you create substantial bodily harm. So those are the underlying charges. And I think that to some extent, the charging decisions reflect what the prosecutors seem to think are going to be issues in demonstrating an intent to kill, that they have selected charges that they think they can prove even if they can't prove that the officer specifically intended to kill. Could they prove that the officer specifically intended to kill? I want you to think back on those very uncomfortable 8 minutes and 46 seconds we had of silence. It's a long time. Could you form the intent to kill during that period of time, even if you didn't start out to kill? Absolutely. Could you possibly premeditate killing within that interval of time? Perhaps, but I think that the charges here reflect that the prosecutors think that they're going to have difficulty specifically proving that the officer intended to kill. A couple of other very quick evidentiary issues to flag for you. One, I've been asked questions about the competing autopsy reports here, and those are very reasonable questions to ask. Note that both the autopsy report that was commissioned by Hennepin County, as well as the independent autopsy report commissioned by George Floyd's family, both of them reached the conclusion that this is a homicide. And all homicide means is that one person killed another person. It doesn't mean that they murdered them, that they killed them intentionally, that the killing was negligent, or that they were even at fault. It's that one person killed another person. So in that sense, the two autopsy reports actually are consistent. Both autopsy reports also seem to think that the officer's conduct contributed to George Floyd's death, although they seem to differ in terms of to what extent the officer's conduct contributed and to what extent there might be also contributions from underlying health issues. The underlying health issues, according to the county's reports, do contribute. The underlying health issues don't, according to the private autopsy. Does that necessarily matter? I'm not sure really that it does. Criminal law requires you to do two things. It requires you to prove that the defendant is the but-for cause of the harm, here the death, and it doesn't really seem to me like either autopsy report disputes that, that if it weren't for the fact that George Floyd encounters that officer on that day and has this encounter, that he does not die. The question is whether or not it's fair to hold the officer responsible as the narrower category of the proximate cause of the victim's death. And that, again, may be more of an issue at trial. And that might be where you might see some discussion of the competing autopsy reports. As a former defense attorney, would I like to see competing expert reports at trial? Absolutely. Would that give me an opportunity to make arguments I otherwise probably couldn't? If the experts can't agree, how can you as a juror necessarily trust that you're being presented the truth? Absolutely. So I would expect that to be an issue at trial. The other evidentiary issue that I've been asked about that I think is reasonable for us to think about is, how does Derek Chauvin's history of police violence come up at trial? Does it come up at trial? Do the jurors get to hear about that? And the answer is maybe, right? One way the jurors might get to hear about it is if the officer himself decides to make an issue out of his character at trial. If he says, I'm a nonviolent person, I would never hurt anyone, I absolutely would never create harm, that opens up the door to have a conversation about his character, which can't include proving that he's engaged in prior incidents of police brutality, but does permit you to ask about them. And so that's one way that his record might come up at trial. The other way it might come up is through a rule called 404B, which every state has, which permits you to introduce evidence of someone's prior bad conduct if you're introducing it for some other reason than to just say he did it before, so he probably did it again. So you can't, for example, introduce a prior incident of brutality to say, well, he engaged in this incident, so he probably did the same thing here. You can't do that. But if you're introducing it to show something else, anything else, like his motive or intent during the course of that encounter, then you can. And I might expect the prosecutor here to introduce some of the prior record for that purpose. Finally, the accomplices, I think that we know less about the investigation of their role. Most of what we know is either from the complaint that Professor Hardaway described, or from, for those of you who have watched the videotape that we've seen of some of those other officers also leaning on George Floyd. So I have less to say about them, but again, if they are helping and even being present in a way that's encouraging to your fellow officer, arguably is helping in a way. Holding back bystanders and getting them not to intervene could be helping in a way. If they have helped and if they intend for the assault to occur, then they're guilty just as if they themselves had performed the act.
That's pretty remarkable descriptions. And very vivid. Thank you for that description. And in thinking about the fact that these police officers acting in concert to commit this murder, to act in a way, to enact, or I should say, to act upon apparently policies that existed or that they believe to exist, to allow them to do the things that they did. I want to move to the next question. This idea of those policies. Can you discuss the policies that give the police the authority in general to use force? And in addition to that, discussing the other policies that come into play in these situations, such as a duty to intervene, a duty for one of those cops to say stop, right, for example. Would you care to sort of respond to that? Who's going to go first, Ayesha or Deb?
I think I'm, go ahead, Deb, are you going?
Deb goes there. I think Deb.
Yeah, I think what we are going to do is I'm going to talk to you very briefly, because it won't take very long, to talk about sort of the ways in which the federal Constitution, which is the main document we have that's supposed to constrain police behavior, the extent to which that actually occurs. And then Professor Hardaway is going to talk to you a lot more about what states actually do. Because again, for those of you without a law background, the federal Constitution is the absolute floor. It's the very minimum of the amount of control and regulation and rights we're supposed to have. States and localities are always free to provide more. So if they want to tell police officers, for example, you can't perform a full custodial arrest for somebody who's allegedly passed a counterfeit 20 or a misdemeanor offense, they can do that. But the federal Constitution says, we don't care, do what you want. So the amendment of the federal Constitution that controls police use of force in encounters like this. So if they are stopping someone because they're suspected of a crime, or if, as here, they are trying to perform an arrest, is the Fourth Amendment. There are other provisions like due process or equal protection that you might feel like should come into play if you're dealing with police encounters. But the Supreme Court's been very clear, if what you're doing is challenging police use of force, nothing else applies. Your claims have to go through the Fourth Amendment. And what the police officers are going to be subjected to constitutionally is a requirement that the use of force that they engage in be reasonable. Unfortunately, that's as much guidance, at least according to our Supreme Court in its current incarnation, as you're going to get. There was an original case called Tennessee versus Garner a few decades ago, in which the Supreme Court did look like it was kind of laying out fairly serious requirements for police officers who wanted to use potentially deadly force. And I think one of the things Professor Hardaway is going to talk to you about is whether or not something like a chokehold might comprise deadly force. But in that case, the Supreme Court seemed to be pretty clear. You're only allowed to put someone at risk of death if they have committed a violent felony, they are posing a danger to the community, and you've given them some sort of warning. That was a case that involved a 15-year-old boy, a middle schooler, who was trying to escape an unarmed house robbery over a back fence, and police officers shot him because they couldn't keep up. And the Supreme Court said, you can't do that. These are the kinds of things we're going to require you to do. But the Supreme Court then pretty quickly beat a path back from that. And so there's a case called Scott versus Harris, in which Justice Scalia, writing for the majority, said, look, it may have looked like what we were doing in Garner was giving you a formula. There's no formula. Reasonableness is, these are his words, a fact-bound morass. And so what that means is that you're supposed to look at the individual facts of each case, weigh the individual's interest in their liberty, their autonomy, their life, against the state's need for intervention. Everyone, both the individual and the state's need to process the person and bring them to justice, right? You're supposed to balance all of that. But the Supreme Court's been very clear. We're not going to give you any more guidance other than that. Reasonableness, that's it. So that's what the Fourth Amendment says. The use of force has to be reasonable. Of course, if what you want to do is challenge the police officer's use of force, it doesn't actually come up as an issue at a criminal trial. If police officers used a lot of force in arresting you, that's not something you can challenge during your criminal trial. What you do is you bring what's called a Section 1983 action, which is a federal civil rights law that allows you to say, I was treated unconstitutionally. So here, an unconstitutional use of force. So I think that originally a lot of people thought that would be a great way to maybe rein in police officers, that when they engage in constitutional violations, I can sue, and that will make it so that they don't do it again. They have a disincentive. The problem is that the Supreme Court says that it's not enough to show that there's a constitutional violation. There has to be a clearly established constitutional violation. In other words, the officers need to have been on notice that what they're doing is unconstitutional, which doesn't necessarily mean, but many courts interpret it as meaning, there pretty much has to be another case in which the officer did the exact same thing under the exact same factual circumstances, and a court found the action to be unconstitutional. Part of the problem is that the Supreme Court, in saying you have to show both that the action was unconstitutional and that it was clearly established, is that courts, in deciding whether or not that's true, can start with the second question. In other words, is it clearly established that this was a constitutional violation? If the answer is no, they don't have to decide if there's a constitutional violation in the first place. What does that all mean? It's pretty rare now that courts are going to be reaching a conclusion that a novel constitutional violation has occurred. What this all is a part of something a lot of you have probably heard about in the news now called qualified immunity. That's the doctrine that allows police officers, unless there has been a prior case that announces a constitutional rule that they're clearly on notice of, to escape immunity from suit. So that's one doctrine that really constrains the ability of people to use the Constitution to protect them. People who want to use injunctions to try to stop police officers from engaging in suits going forward, that's also a route that's fairly foreclosed. The Supreme Court in a case called Lyons actually considered not the exact same kind of restraint used here, but a chokehold that was being challenged by someone who it was used on, and said, well, you know what? I know what you're seeking is injunctive relief. In other words, that police officers shouldn't be able to do this going forward. But if you want that, you have to show that this harm's going to happen to you again. In other words, that you are going to be arrested by the police and they're going to use the same hold personally on you again. Makes it very difficult if that's the argument you have to make, which the Supreme Court said, we don't think anyone's going to be able to make that. It makes it very difficult for you to get injunctive relief either. Police departments themselves, generally, unless whatever it is that's being challenged is part of their training, their actual pattern and practice of behavior, it's difficult to sue police departments under civil rights laws. So I don't mean to leave this and turn this over to Professor Hardaway on a dismal note, But this is kind of a message that, again, at least as currently interpreted, the Constitution is not, unfortunately, coming to save people from excessive police use of force.
I think as you were talking, I was feeling like, so basically the best imagery or description of what we've known for a long time now is that you need to be a unicorn and lightning has to strike you twice. And right, and then that's the only way that you'll get relief, at least from the federal courts in a civil manner. I would like to just add that under Ohio law, excessive force is the use of excessive force can be levied as an affirmative defense for individuals who are being brought up on charges by the police department for resisting arrest or assault on a police officer or the like. You can assert and ask for an instruction to the jury on the use of excessive force as an affirmative defense. But that is state law here, and I can't say that it's all that useful, but it does exist on the books. Okay, let me try to share my screen for this last final slide, and I see we have questions. We're going to wrap up soon. I just have to remember where I am. Okay, so let me just do this. Oh, no. Well, oh, that was fast. Sorry, guys. I hope I didn't make anybody dizzy. Why is it not? Let's see. There we go. Okay. So I just want to spend a little bit of time talking about the specific policies because I think Professor Ahrens is exactly right on the Constitution being the floor. It absolutely is, but there are certain things that are going to hopefully be presented in court as to whether or not the conduct of these officers was in fact reasonable. So as you're dissecting the fact-specific details in order to understand what's reasonable here, I think certain things may be brought up. And so I have the link up here to the Minneapolis Police Department's use of force policy that I could share in the chat later when my hands are less tied. But I think these policies are important for the discussion because they touch on not just the use of force, but also chokeholds and duty to intervene. So portions of Minneapolis use of force policy were last updated by the department in 2017. And other sections have remained unchanged since 2007. I'm going to try to not repeat all of what you've said in some places, Deb, but the policy incorporates and quotes Graham versus Connor, the Supreme Court that Professor Ahrens mentioned to you directly in the policy. And it's been cited for reliance on the fact, as she mentioned, that each use of force, in order to determine whether or not each use of force is reasonable, you have to look at the specific facts of the case. And the policy points to 3 different factors that must be evaluated. And that's the severity of the alleged crime, the level of the resistance being put up by the person being arrested, and if that individual poses an immediate threat to officers or the public. The policy goes on to expressly give greater credence to what an officer says he thought was happening in the moment, rather than what was later determined to be a true level of threat. So as many know, in Graham versus Connor, the Supreme Court determined that it was reasonable for officers to detain, handcuff an unconscious man and assault him in a manner that led to many injuries, including a head injury, broken foot, and cuts on his wrist, and then dump him, Mr. Dethroned Graham, on his front lawn, despite the fact that he was in the midst of a diabetic health emergency when officers encountered him, and not robbing a gas station in 1984 in Charlotte, North Carolina. But the focus, I don't want to put too much focus on Graham, because I think it is important, as Professor Ahrens mentioned, to identify the relevancy of Tennessee versus Graham because of the use of deadly force there, right? So uses of force can vary from a whole bunch of levels. now pointing a weapon is widely accepted by policing experts. I'm not saying departments, but by policing experts as a use of force. Handcuffing somebody is deemed to be a use of force, all the way up to shooting someone or using a chokehold, those deadly uses of force. And the policy manual in Minneapolis plainly states that the use of deadly force simply for the purpose of preventing an escape is unreasonable under all circumstances. So if your only purpose is to stop someone from getting away, then you cannot use deadly force. But the manual is skimpy on its guidance regarding how to apply Tennessee versus Gardner, or even its own policy. It only recognizes that the use of weapons, both lethal and non-lethal, can constitute deadly force, but fails to make any connections between the reasonableness and the use of chokeholds or what they also call as neck restraints. So in a separate section, the policy goes on to expressly allow appropriately trained officers to use neck restraints and chokeholds. And it lists 3 different types. The deadly chokehold is the first one. What they call a conscious neck restraint is the second. And then an unconscious neck restraint, which is where you restrict the blood flow to the brain in order to put someone to sleep, is the third one. And that is why you're hearing some news reports mention that the use of force used by the officers seen in the video is allowed by policy. The unconscious neck restraint is only permitted when an individual is seen or viewed as being actively aggressive and is actively resisting, or other attempts to gain control of the individual have been or will likely be futile, or if the officer is acting in order to save a life, his life or someone else from the public. And so I think that those things are really important to mention because it's widely known now, I think, across policing experts, and those of you who've been following the news, I hope you've seen, bless you, that law enforcement authorities across the country have been denouncing what they saw in this video, the conduct of former Officer Chauvin. But the duty to intervene is another separate part of the policy that was added to the Minneapolis policy in 2016. And it requires every sworn employee present at a scene where physical force is being applied to either stop or attempt to stop another sworn employee when force is being inappropriately applied or is no longer required, right? So that the length of that 8 minutes and 46 seconds is really important in terms of when things change and when it's clear that the use of force, well, you may question whether or not it was necessary in the first place, but certainly at some point, it certainly was no longer required. And that directly implicates then those 3 other officers on the scene who did not have their knee directly on his neck, but 2 of whom we know assisted in holding him down, and all of whom failed to stop former Officer Chauvin while he applied deadly force to an individual who was not actively resisting. So let's see. The last thing that I would like to really highlight for all of us, I think it's important, especially because we live in cities where use of force policies exist everywhere you are, right, is that the policy in Minneapolis, as many of them do, center on the sanctity of life. That's how they start their policy. Yet the incorporation of procedures and techniques such as neck restraints into the policy as recently as 2012, with the false assertion that not all such restraints constitute deadly force, defies medical logic and amounts to instead a disregard for human life. This type of technique was popular across law enforcement until the 1980s, but many departments acknowledged what they were faced with, which was the undeniable reality that using techniques that restrict blood and air to the brain results in the death of people. It kills people. And so the officers decided to completely ignore the fact that Mr. Floyd was not resisting, was asking for help, and was telling them that he could not breathe. They also ignored observations from bystanders to the same. So I'll leave it there, but I think it's important that we have the policy for the context of understanding how use of force, both deadly and non-deadly, as well as the duty to intervene, will be important to the analysis, the judicial analysis of what happened here.
Thank you, Ayesha, on this clear explanation of the various mechanisms and rules and policies regarding use of force, from the chokeholds, neck restraints, and this important thing that we saw live is this issue of the duty to intervene. What I'd like to do is sort of blend our final two questions, because I want to get to some of the questions and thoughts of the people who are watching and listening. So I wanted to ask you both, maybe starting with Deb, what can audience members do in terms of action items based on what we've seen, based on what people are feeling and experiencing? I want to ask both of you that question, and then that other question that I was going to ask directly to you, I'd like you to sort of weave that into the Q&A portion. That is the issues of criminal justice, race, and law enforcement. Let's take that theme and weave it into the Q&A so we can get to those. But I do want to get from both of you first. What are some of your recommendations or prescriptions about people who are wondering, how can I engage in addressing these issues of social and racial injustice that we're seeing, particularly as regards to police and law enforcement?
Right, and what I would say is, in the same way that, criminal law can be a very hard area to be in because the law is very different in every state and it's very local and it's very state driven, if what you're looking for is reform, that's a blessing. And so for those of you who might have sat through this, or certainly sat through some of my dismal presentation and said, well, that doesn't sound like there's much room for us to improve. And the answer is there is. As I said, the fact that federal law doesn't address things doesn't matter if what we're dealing with are issues that are primarily state and local. And so there are certainly a lot of legal changes that I can think that you could work on at a state or local level that would make a big difference. One thing is to think about, are there things that we could treat in a way other than with criminal law? The police don't necessarily need to show up, right? If what you're dealing with is something that is not a criminal law problem. And again, because I write in the area of drug policy, that's certainly something I think about a lot. Are there ways to address the obvious harms of substance use disorders without resorting to criminal law, which has its own negative effects and destroys communities and takes people out of them and robs them of their parents? And so that's one thing to think about, are there things that I think shouldn't be treated by criminal law in the first place? If things are treated, and also, are there things that maybe police don't need to respond to? Are there things that we could come up with another group of first responders who could respond that would be more appropriate to the situation? I think Ta-Nehisi Coates has this great quote about how asking why police officers are bad at dealing with, for example, mental health situations is like asking, why is it that hammers are so bad at fixing refrigerators? It's just not. We can try to talk about maybe training officers to be better at de-escalation, to be better at dealing with people who are experiencing mental health crises, but it's simply not kind of at the core of what they do. And so we can think about what kinds of actors and institutions in our community are better positioned to respond to those kinds of problems. So two things that kind of go hand in hand. More accountability for police forces. Professor Hardaway is much more of an expert than I am in things like civilian review boards and consent decrees and things where we do impose some outside controls on police officers. Historically, a lot of those institutions have been relatively toothless. They haven't had the ability to impose disciplinary findings on police officers, for example, or if they get a citizen complaint, they can recommend, but they can't require. And so to have outside civilian review boards that have teeth to the extent that you're going to have a police force, which presumably if it's not doing as much policing, you wouldn't have as much of it. So those are things that you can absolutely do at a state and local level. At a federal level, eliminating qualified immunity is something that a number of presidential candidates have said is part of their platform. And it's actually an issue that absolutely transcends party. This is something that people on both the left and right, many agree, it's a bad idea to protect police officers from the consequences of their actions. And we see the results of that every day. Finally, if you're just looking for something you can do today, you can donate to bail funds, right? Whether it's because you're seeing people who are being arrested for protests or just people who are arrested for relatively low-level offenses who are sitting in COVID-infested jails right now. That's something you can do as an action item today. An awful lot of people are sitting in jail not because they're in any way, shape, or form a harm to the community. And again, you can think about reshaping state law so that a lot of things that are currently arrestable offenses that could land you in jail with a literal $50 bail that if you're poor, you can't pay, simply wouldn't be arrestable offenses. But for those folks who are stuck in the current system, bail funds, there are a lot of them right now, locally, nationally, and a thing you can do today is Venmo $5. Thanks.
Ayesha?
So I'm going to be really quick because I want to allow for questions. The three things that I'll say. The first is that I put the link to Minneapolis's use of force policy in the chat just to show that most places, hopefully, they're easy to find. That may not be true. You may have to file a public records request. You may have to make a telephone call and talk to a few people here or there in order to actually figure out where the link is. But I think it's important if you want to have an understanding as to whether or not archaic techniques, dangerous techniques that folks are trying to say are not deadly, but in fact really are permitted in your municipality. I think you should look at those and then have conversations with your elected and appointed officials, use your power and your leverage and your influence with your elected and appointed officials to make sure that they don't stay as a part of the policies. And then the other thing I would say is, I mean, I think, and I know that Deb is absolutely right in terms of how some civilian oversight boards most civilian oversight boards can be toothless in a lot of ways. I believe that, but there's a way to make them have more power that also involves having conversations with your local and appointed officials, but demanding that there is community engagement baked into reform processes at the outset is so critical to this work. It cannot be enough that they come and talk to communities while they're doing investigations and then stop talking to communities impacted by police violence when they start making decisions about what the policies look like. We have got to make sure that there is some accountability to the communities being impacted in the reform, or what I would hope at some point become transformation efforts. Union contracts, there was a question that was asked. I happened to actually see it from, let's see, from Laura about why are we in this place where an individual who has a bad history is allowed to still be on the force. I don't know the details of former Officer Chauvin's disciplinary history, but I will tell you that union contracts do an enormously good job of making it such that those disciplinary things that have been brought, administrative hearings that have been held or investigations that have been held, that they don't interrupt, right, the employment of police officers in the way that many of us would like for them to. If I am bad at my job, my dean, one of my deans is on this call. If I am bad at my job, he gets to dismiss me at will. I don't get to be terrible and just keep a job. I don't get to be terrible 1 year and then 2 years from now have it erased as if it never ever happened. And unfortunately, police union contracts allow for that type of erasure to take place. And then you have individuals who have a pattern of problematic conduct still allowed to police our streets. And so those are the three things that I would offer up as possibilities for folks to address.
Well, thank you both. Let's go into a couple of questions. Claudine, are you here? Can you hear us?
Hi, I'm here. We have a question from the beginning. Let me just scroll back. About whether or not the police officers' supervisors have any legal exposure. Given it says his superiors knew about his propensity to act in a questionable manner.
So, I mean, so criminal exposure, obviously, I don't think that there'd be a real causation issue. And Professor Ahrens, please, if you want to, you can speak to this, a real causation issue. But this is the moment where, right, the superiors are in fact the appointed officials. And this is why you will see, for instance, just recently in Louisville, there were 2 officers who apparently were involved in the shooting of a man during a protest earlier this week, and their police chief was fired. The police chief was fired, not just, I'm sure, because of that incident, but also because of the fact that Breonna Taylor was killed in her home during a no-knock raid. So that is the way, I guess, that the system allows for addressing the failure of superiors to do their jobs. But on the criminal end, I think you'd have a real causation issue.
Right, and on the kind of civil liability side, again, the police department itself is pretty much immune from suit unless you can show that this is their practice. And as Professor Hardaway has outlined for you, Minneapolis is in the minority of jurisdictions out there that permit chokeholds at all. So again, that's a thing that people can do locally, which is to, in a state or a locality, create a rule or a law that says you simply can't use that particular kind of force. Constitution won't prevent it, but you can certainly pass such a regulation locally. But he wasn't doing what he'd actually been trained to do. He wasn't supposed to continue with that, again, questionable restraint in the first place, but he wasn't supposed to be continuing with it in the way that he did. That wasn't department policy. So it's going to be hard to hold the department or his supervisors liable for it. And I agree with Professor Hardaway, the causation issues, it's very difficult to hold someone vicariously liable for what their employees do. And this doesn't seem to be the sort of case where it would fall into one of the categories where you might be able to.
We have a question from Tamaya. I hope I'm pronouncing your name correctly. If you want to go ahead and I'll unmute you and you can ask your question.
Yes, thank you everyone. Thank you for Seattle University for facilitating this really salient conversation. So my question is, in light of Professor Ahrens' explanation of qualified immunity and Section 1983, this sort of gives rise for avenues to seek justice outside of the judicial system. So from a criminal justice perspective, there's a movement which is gaining traction both nationwide and here in Seattle of defunding police departments. So in effect, reducing policing budgets. So how can we conceptualize this in terms of systemic change?
Right, and if I can respond to that just quickly, one thing that I found when we think about defunding police departments is people mean different things when they say that. Sometimes people mean police abolition, which is we eliminate that particular institution and create a new institution or new institutions. And so that might be one thing that would be defunding police. Another thing, I mean, I've heard people describing what Los Angeles is doing right now as defunding police, where they're reducing their police budget by about 16%, which is significant, but not quite the same as abolishing police. So it really kind of depends what people are arguing for, what they're using that terminology for. But absolutely, as I said, my thought is that we use police for things that police aren't trained to do, that we probably maybe could train them to do, but really isn't kind of at the core of what we ask police to do, that probably could be done by other folks. And so at the very least, I would think that the Los Angeles approach would be one that a lot of people could be persuaded to engage, right? That we have other institutions take over some of those functions, or just don't address some of the situations that arise that people call 911 about at all. Thinking about creating a completely different institution than what we call police. I mean, I think that that's a more difficult conversation, and one that 10 years ago, I would have said that would be impossible for us to have. But I think that a lot of people are open to having that discussion now.
I'll go to the chat for another question here. It says we have 18,000 different police agencies in this country. How is it that no department, no mayor, no police chief can innovate and prioritize civilian lives?
I think that was rhetorical. I don't think there's a... Agreed.
Okay, let's see. Does anyone, I'm not seeing any
There's a
can.
question around, there were a couple questions that I saw. One about my slide that said that there was, what did it say, white foam around Mr. Floyd's mouth. Someone asked me what caused that. I have no idea. All I know is that the probable cause statement said that that was noticed by Officer Lang, and it prompted him to ask him if he was under the influence of anything. When I read that, I thought it was really curious because I've been talking for a long time, and thank God I can see in the camera there's no white foam in my mouth, but at different points in time throughout the day, it will appear, and I try to catch it. So I don't know. I have no idea what it means, but I can tell you that's the context in which it was offered.
Okay, we have a question from Avedon. If you want to go ahead and ask your question.
Sure. Thank you, Ayesha. Thank you, Deborah. My question relates to, I guess, what I see as our all too great reverence for the law. You know, the late Justice Thurgood Marshall said that, you know, the Constitution was defective from the start. You know, credit for the end of slavery doesn't go to the framers. It belongs to those who refuse to acquiesce in outdated notions of liberty, justice, and equality. I guess, and I know this is a fairly broad question, but what changes to notions of liberty, justice, equality do you believe we need to make to eradicate state-sanctioned violence against Black and brown bodies?
That is a big question. I mean, I think that, right, part of the problem is, and we're law professors, and so this is what we do, right? What I think about is what can we do through the law? And on the other hand, law is not coming, I think I've been clear, law is not coming to save you, right? It is a tool that you can use for change, but it reflects us, right? It reflects our choices. And so, right, we have to, even those of us who are thinking about this within a legal framework, we have to make different and better choices in order for us to have the world that we want, right? And I think from my perspective, I don't have an answer for you about what values to center or what to think about first. I think that one of the things I would like us to do is start from the beginning and think about, is this a particular kind of law that we need? Is this a particular kind of institution that we need? Because I do often feel like we're rearranging our deck chairs on the Titanic, right? We'll give the police officers one more training on implicit bias, and maybe this will be the fix, right? As opposed to thinking about, do we need police? And if we do need police, do they need to look like this? And do they need to do that, right? So to really think from the very beginning about how the choices we've made to create particular laws and institutions reflect who we are now and who we've been, and what do we want to do going forward, and to the extent that we have law, have it reflect that.
Yeah, the only thing I'd add to that is just, right, I mean, the reality of the situation is that the status offenses that we have on the books now can absolutely be traced back. There is a thread from the bounty hunting of the slave patrols, right, pre-emancipation, to the sheriff's deputies and the working in concert with the KKK, right, after emancipation, to what we see right now. And until we get real about the origins of policing in America and the creation of laws, for criminal laws for those purposes, we'll keep spinning our wheels. And so I agree that we need to start talking about those real fundamental issues in order to see a difference in impact and effect.
Okay, here's another question from the chat. Dr. Ahrens mentioned that felony causing death without intention to affect death, the second option for secondary murder, is what Mr. Chauvin has been charged with. However, if the act is assault, then it merges into the murder charge, and assault can't be categorized as a felony. Mr. Chauvin was physically assaulting Mr. Floyd by kneeling on his neck while he was handcuffed. So can you please explain why his actions are being qualified as felony as opposed to assault? What action of Mr. Chauvin's is being categorized as felony?
Right. Well, and I do want to clarify, I do not have, unless you count my Juris Doctor, I don't have doctorate. So I am professor. I don't want to take on a title I don't have. The YouTube folks will hunt me down at some point. But what I will say is what you just said in pretty much every other jurisdiction, that's true. And so when I saw the charging document, my first thought was that doesn't seem right. But then my second thought was, well, I'm guessing that the Attorney General of Minnesota knows something about Minnesota law. I don't. And so I did actually go, and again, I will not claim that I did exhaustive research on this, but I did go ahead, pull the statute, pull the committee notes on the statute, and pull the cases applying the statute, and found that actually the Supreme Court of Minnesota has said that the merger doctrine, which normally would merge an assault into a killing such that the assault can't be a predicate for felony murder, that it doesn't apply in Minnesota. So I would, and I've got to say this, I would absolutely hate if this case were to end up being the occasion for that state to be having a conversation about whether or not to revisit that doctrine, whatever my other separate thoughts may be about felony murder and about the lack of a merger rule in the first place. And again, it's part of why I wanted us to think about, are there arguments that this is an intentional killing that a prosecutor could make that would make this second degree, or even if you think it was premeditated first degree murder? But no, it seems that Minnesota is an outlier in the area of felony murder.
Can we still take some more questions?
Let's take 2 or 3 more questions and then I'll wrap up. Yeah.
This question is about qualified immunity. What is the process for reassessing the limitations of qualified immunity? Would that fall to the political and legislative process?
I guess we can sit here and stare at each other. I'm sure we both know the answer to that.
Yeah.
It is an entirely judicially created doctrine.
Entirely.
There's no law. So this is something, you know, of all the things that you could just like fix tomorrow, Representative Amash actually has a bill that he's introduced to eliminate qualified immunity. Like, this could go away tomorrow. I mean, not because of anything I personally do, but this is one of those write and call and pester your congressional representatives about, because it's a fixable problem, because it's a court created problem.
And it's actually, it keeps being brought, cases keep being brought in front of the Supreme Court, the US Supreme Court, waiting for them to take up the issue, and they keep bowing out. It's my understanding that there's still a handful or maybe 2 handful of cases in front of them this term that folks are waiting to see if they will actually pick them up.
Right. And again, it's one of those things where this is not a partisan issue. The 2 justices who are most opposed to qualified immunity are Justice Sotomayor and Justice Thomas. And so Justice Thomas, because look, this does not, there's no statute, it's not the Constitution. Where is this coming from? If I don't see it, it's got to be abolished. And Justice Sotomayor also from there's no actual statute that this is coming from, and also from well, you have to be able to hold police accountable, right? Perspective. If we have a civil rights law, there has to be enforcement. So again, it's not a partisan issue. It is something that's fixable. And I think Professor Hardaway is right. There are even Supreme Court justices who might be happy to overturn it. It's just the legislative approach is much more direct.
Absolutely. And we need more Supreme Court justices willing to overturn it.
Okay, I can look for more questions, or would you like to wrap up, Professor Adamson?
One more question. I saw a couple of them. Just ask one more question and then we'll wrap up. I want to make sure we try to get as many people honored as possible. I see one here.
Yeah, go for it.
How would you respond to someone who feels that a nonprofit making a statement condemning the killing of George Floyd and systemic racism contributes to a national atmosphere that creates an impartial, biased trial and violates the officer's Sixth Amendment protections to a fair and public trial? Did you follow that question, Ayesha? Deborah?
I think I do. I can't see the person. I can't find it in the chat right now. But the first time I read it, I was I thought the question was perhaps asking if nonprofit orgs have somehow infringed upon the rights of these officers to have a fair trial. And like the First Amendment, all amendments require government action in order for us to have some sort of impairment or infringement of them. If the writer of that question, if I misunderstood that, the writer of the question, please feel free to take yourself off of mute so that I can understand it better.
I think you got it correct. It was what are we, by making a statement, violating the police officer's Sixth Amendment rights by already holding them accountable of sorts? I've gotten some pushback in an org I'm involved with, and I'm trying to think of ways to respond to that.
That's so interesting. That's so
I know.
How many mugshots do you see in your local newspaper, right, of individuals who are arrested but not tried? Has anybody ever tried to give pushback to the media and tell them that they shouldn't cover criminal activity in the local news because it's creating, right? I'm a defense attorney, so I understand the point. I'm sorry that your org is going through that, and that this topic is the thing that's making people think about it in that way.
Yeah, and I would agree. You are not the jury, you are not the judge, you are not the government, and so there's no even plausible actual constitutional violation in terms of, are you to some extent contributing to an atmosphere where it's going to be difficult for the former officers in this case, to get fair trials? I mean, welcome to the criminal legal system, right? And for better or for worse, we've had, I don't know how many high profile trials, some of which where I would imagine probably publicity and organizations taking statements may have influenced parties one way or the other, but it's kind of endemic to living in a society. And we've had a number of trials related to police brutality, whether it's Philando Castile, whether it's the Powell and Kuhn officers in the Rodney King case, where there's been a tremendous amount of national publicity and condemnation, and still the officers get acquitted. So it seems that it's possible to receive a fair trial, even in the face of that kind of publicity.
Thank you, Deborah.
Thank you.
And thank you, audience member there. We're going to wrap up with some thank yous, and I want to talk about a few resources and talk to you about what we're going to do next week, and then just a brief closing remarks, if I can. First, I want to give just heartfelt thanks to Deborah and Ayesha for educating us, educating our students, educating our community members, so they're equipped to understand and listen and grapple with in a more thoughtful and intelligent way these incredibly difficult issues, and these troubling issues that have been dogging us for 400 years indeed. So I can't thank you enough for the education. So thank you. We know that there are also Case Western Reserve in particular, and also SU in particular, but everyone has community members. We have community members who are going through sense making of this and going through emotional stress and mental stresses of this continued assault on Black bodies and brown bodies, and the state sanctioned violence that we are confronting head on here has just really made life a living hell for so many of us. And many of us don't know where to turn other than to each other and to withdraw. But I did want to just sort of remind particularly our students at Case Law School and our students at SU Law School that the universities have some resources that you can use and if you need to have talk conversations or talk through some things. And there are many community organizations out there that do that also for members of our community who are listening, who are in need of those types of services. So Case Western's University Health and Counseling Services has, call-ins. You can have one-on-one conversations with counselors. They even have specific counselors that will talk with you about these issues that are unique to us as minority students or faculty or staff. They're students of color support space. Seattle University also has scores and scores of counseling and psychological services available through CAPS. There are crisis hotlines and supports. There are community groups, LGBTQIA friendly healthcare and counseling services in the Seattle area. So if you need assistance, please reach out and don't be afraid, don't be shy about getting help, helping you and us work through these very difficult issues. As I hinted to at the beginning, what we're hoping to do jointly with Case Western and Seattle University is continue on with a few more of these conversations, these town halls, and my aim is to do one next week. So as Rachel Maddow would say, watch this space, watch our Facebook space. And we're going to actually pick up on some of the things that Professor Hardaway and Professor Ahrens just discussed. That is police reform, law enforcement reform. And I'm gonna have experts talking to us about, okay, what's going on in that space? What's going on with regards to reforms? What's possible, what's not? And so we're hoping you'll join us for that as well, because we think that's gonna be a very important, useful, valuable, informative conversation to be engaged in. So we'll let you know about that. And I just want to close once again by saying thank you to the audience members. Thank you for your thoughtful questions, your thoughtful reflections. Thank you again to Ayesha and Deborah. And I wanted to leave you with a quote, a statement, a passage from James Baldwin. And I thought about this because, I'm some things that are seared into my head right now, listening to Ayesha and Deborah, are these issues of how nothing is an accident, right? This idea that the Constitution can't save us, that the laws and policies are there intentionally. The system is working exactly the way they intended to work, right? And the way that intention is reflected is this continuous assault on Black and brown bodies that has as its root racism, our original sin. Right? And this is the thing we're all talking about, we're all grieving about, that we're seeing right now. And this is the thing we have to fix. And James Baldwin wrote in The Fire Next Time, in his letter from a region of my mind, he talked about this, right? He talked about this in the context where God was discussing his warning to Noah, after man had just managed to mess up the earth, right? And that led him to flood the place, right? And to start over. And I believe, in my bones, that is the thing, that is our corruption, that racism is our corruption. And it's a thing that will bring us down if we do not confront it and kill it, right? And so he said this, that there was going to be resistance. There was going to be white resistance. But he could also see that intransigence and ignorance of the white world might make that vengeance of God's inevitable, right? A vengeance that does not really depend upon and cannot really be executed by any person or organization, and that cannot be prevented by any police force or army. Historical vengeance, he was talking about, cosmic vengeance based on the law that we all recognize when we say whatever goes up must come down, right? And here we are, James Baldwin continues, at the center of the ark, trapped in the gaudiest, most valuable, and most improbable water wheel the world has ever seen. Everything now, we must assume, is in our hands. We have no right to assume otherwise. If we, and now I mean the relatively conscious whites and relatively conscious Blacks, if we, who must, like lovers, insist on or create the consciousness of others, we cannot and do not falter in that duty now. We may be able, the handful that we are, to end the racial nightmare and achieve our country and change the history of the world. But if we do not dare everything, the fulfillment of that prophecy, recreated from the Bible in song by a slave, "Oh Mary, Don't You Weep," a slave song, that prophecy will be upon us. God gave Noah the rainbow sign. No more water, the fire next time. So it seems to me that the time is now for us to dare everything. We got to get it right. And I really thank you for joining us and sticking with us. And once again, thank you for your contributions. And we'll see you all on the other side. Be strong, stay safe, take care of yourselves, and importantly, take care of each other. All right. Bye-bye.